An operating agreement and bylaws are both essential governing documents for different types of business entities, and they outline the structure, management, and overall functioning of the organization. However, there are some key differences between the two. An operating agreement is a legal document used by limited liability companies, the LLCs. It is not mandatory in all jurisdictions, but it's highly recommended for outlining the company's operations and internal management. The operating agreement defines the roles, responsibilities, and financial contributions of the members, the owners of the LLC. It outlines how profits and losses will be distributed, the management structure, voting rights, and procedures for adding or removing members, along with other provisions. Operating agreements are generally more flexible than bylaws, as they can be tailored to fit the specific needs and preferences of the LLC members. While not always required by law, an operating agreement is a legally binding document that governs the relationships among the LLC members and helps protect their limited liability status. Here are the parts of your operating agreement. Part 1, figure out the percentages of ownership. Obviously, in a single member LLC, that member owns 100%. Part 2, rights, responsibilities, and compensation details. The reality is, protecting individuals is one of the most critical aspects of an operating agreement. Part 3, terms of joining and leaving. For example, what happens to the ownership percentage if someone joins or leaves the organization? Part 4, dissolution terms. Nobody wants to think of a business failing. However, having a plan will make it far more manageable during this stressful time. And Part 5, severability clause. A severability clause protects specific terms of the agreement in case any part of the agreement is deemed in conflict with state or federal law. Bylaws are legal documents used by corporations, specifically C corporations and S corporations. They're required by law in most jurisdictions and are created as part of the incorporation process. Bylaws outline the rules, structure, and procedures for the corporation's internal governance. They typically address topics such as the roles and responsibilities of the board of directors, officers, and shareholders, the process for electing directors, the frequency and procedures for holding meetings, and the methods for amending the bylaws themselves. Bylaws are generally less flexible than operating agreements, as they must comply with the specific corporate statutes and regulations in the jurisdiction where the corporation is formed. Bylaws are legally binding documents that are essential to maintaining the corporation's separate legal status from its owners, also known as shareholders. They help ensure that the corporation operates in a consistent and organized manner. Your bylaws should include the following: name, address, and place of business, list of directors and corporate officers, duties of each role, number and type of shares and stock classes that the corporation is authorized to issue, meeting procedures, corporate record-keeping details, conflicts of interest, and details on amending articles of incorporation and bylaws. Operating agreements and bylaws are important because they provide a solid foundation for the governance, management, and operation of business entities. Choose the one that makes sense for your business structure.